It was 11 days ago. The guy was 33 years old, had never sat through a single FAA audit in his life, and was standing in front of a conference room full of investors calling the Avionics certification database I'd built over 26 years legacy garbage that any half-decent intern could replace in a weekend. The technical lead in that room was supposed to be me. I wasn't invited. You can probably guess how long that situation lasted. My name doesn't matter much for this story. What matters is that I spent the better part of 3 decades building software that keeps regional jets from falling out of the sky over Indianapolis. Not exaggerating. The system I architected tracks every single component, every maintenance log, every airworthiness directive, every pilot certification renewal, every fuel quality test for a fleet of 240 aircraft owned by a charter operation out of Wichita that contracts with the Department of Defense, 3 Fortune 100 companies, and about a dozen state governors who like to fly private when they think nobody's watching. That last part becomes important later. I joined the company in 1998 when it was still operating out of a hangar with a leaky roof and a coffee maker that had been there since the Carter administration. Back then, I was the only software person they had. The owner at the time was a retired Air Force colonel who shook my hand and said, "Son, I don't understand what you do, but I understand that I need it. Tell me what you need to do your job and I'll get out of your way." That man passed away in 2014. His daughter inherited the company. She was different. Not bad, just different. She wanted to modernize the brand, which meant hiring a marketing firm, redesigning the logo, and eventually, last spring, bringing in a 33-year-old MBA from some consulting firm in Dallas to be the new chief technology officer. His name was Connor Whitfield. I never had a CTO above me before. For 26 years, I just reported directly to whoever happened to be running the place, because everyone understood that what I did was specialized, and nobody else in the building had the credentials to even evaluate my work. Now, I had a boss who'd never written a line of safety-critical code in his life. I want to be clear about something before I go further. I'm not bitter about being older. I'm not bitter about young people coming up in the industry. Some of the sharpest engineers I've ever worked with were under 30 when I met them, and a few of them are still my friends today. What I am bitter about is people who confuse confidence with competence, and who think that a slide deck is a substitute for understanding what actually happens when your code is running at 35,000 feet. Connor walked into the office on his first Monday wearing a Patagonia vest over a button-down shirt, carrying a leather notebook he never actually wrote in, and he spent the first 6 weeks doing what he called a platform audit. That meant he wandered around the engineering floor asking people what they did and then nodded a lot while making faces that suggested he was very disappointed in all of us. He never once sat down with me for more than 15 minutes. The longest conversation we had in those 6 weeks was when he asked me to explain why we still used a particular database engine that he'd never heard of. When I told him it was because the FAA had certified our entire compliance pipeline on that specific stack, and changing it would require 18 months of revalidation work plus an estimated $400,000 in audit fees, he laughed. Actually laughed. He told me, and I'm quoting him directly here because I wrote it down that night, "That sounds like a boomer excuse for not wanting to learn anything new." I'm 58 years old. I started learning new things in 1985, and I haven't stopped since. I have certifications in 3 regulatory frameworks that didn't exist when I started my career. I taught myself a new programming language 2 summers ago just because I was curious about it. But sure, boomer excuse. I went home that night and did something I hadn't done in over a decade. I pulled out my employment contract, the original one from 1998, plus the 2 amendments I'd signed over the years. The most recent amendment was from 2011. When the founder was still alive, and we'd had a conversation about what would happen to my work if the company was ever sold or if I was ever let go. He'd had his attorney draft language that, at the time, I thought was overly generous. Section 9, paragraph 4. I'd actually forgotten the exact wording, but I remembered the gist. I sat at my kitchen table with a cup of decaf and a yellow highlighter, and I read it 3 times. The language said that all intellectual property I developed prior to and during my employment, specifically including the avionics compliance database architecture, the maintenance tracking algorithms, the regulatory reporting modules, and any derivative works thereof, would be considered licensed to the company on a non-exclusive basis, in the event of termination without 180 days written notice, or in the event of termination for any reason other than documented gross misconduct. The license would automatically revert and all rights would return to me as the original author. The company would retain operational use during a transition period not to exceed 60 days, after which continued use without my written authorization would constitute willful infringement. I read it again. Then I read it a fourth time. Then I scanned it on the little printer scanner my wife keeps in her sewing room, and I emailed it to an attorney named Reed Calloway. Reed and I had been friends since college. He'd done well for himself, made partner at a firm in Kansas City that specializes in intellectual property and employment law, and he owed me a favor from when I helped his nephew get an internship at our company about 6 years back. The subject line of my email was simple. I wrote, "Reed, is this still good?" He called me back at 10:47 that night. I remember because my wife had already gone to bed and the dog was giving me the look that meant she needed to go out one more time. Reed said, "Buddy, this is one of the best drafted reversion clauses I've seen in a while. Whoever wrote this knew exactly what they were doing. Why are you asking?" I told him I had a feeling. He told me to start making copies of everything. Source code repositories, documentation, the original architecture diagrams from 1999, every email thread where I'd been credited as the sole author of various modules, performance reviews where management had specifically referenced my work as proprietary to me. He told me to put it all on an external drive and put that drive somewhere that wasn't my office and wasn't my house. I rented a safety deposit box at the credit union the next morning before work. 6 weeks later, on a Thursday afternoon at 3:22, I got a calendar invite for a meeting at 3:30. 8 minutes notice. The meeting was titled Strategic Realignment Discussion. In the conference room, I found Connor, the HR director, and a woman from the daughter's executive team I'd only met twice before. Connor did most of the talking. He explained that as part of his platform modernization initiative, they were going to be moving toward a cloud-native architecture built on a new tech stack, that my role was being eliminated effective immediately, that I would receive 8 weeks of severance contingent on signing a separation agreement that included a non-disparagement clause and a release of all claims, and that security would help me clear out my desk. He never used the words fired or terminated. He used the word transitioned 4 separate times. At one point he said, and I want you to imagine this being said by a man wearing a vest in a charter aviation office in central Kansas. He said, "We just feel that the platform needs to evolve beyond the foundational legacy assumptions, and we appreciate everything you've contributed to where we are today." I let him finish. I didn't argue. I didn't ask questions. I asked for a copy of the separation agreement to review with my attorney, which they provided. I packed up my desk, I drove home, and then I called Reed, who'd already drafted what we were going to do next, because I'd given him a heads up 2 weeks earlier when Connor had started scheduling meetings that conspicuously didn't include me. The first letter went out on Monday morning. It was sent via certified mail and email to the daughter, to Connor, to the company's general counsel, and to the chairman of the board, who was the founder's brother and a man I'd known for 25 years. The letter was 4 pages long. It cited Section 9, Paragraph 4. It enumerated the specific intellectual property covered. It noted that as no notice had been provided, the reversion was effective immediately, and that the company had a 60-day transition window during which they could continue using my licensed work. After that, any continued use, including but not limited to running the compliance database, accessing the maintenance tracking system, or generating regulatory reports through my architecture, would constitute willful infringement. The letter also included an invoice. The invoice was for $2,463,812. That number wasn't pulled out of thin air. Reed and I had spent 3 evenings working through it. It represented 26 years of accumulated licensing fees calculated at market rate for the type of safety-critical certified software the company depended on, minus the salary I'd been paid, plus interest, plus the cost of the transition period and replacement licensing. The math was airtight. Every line item was documented. The invoice was due within 30 days. Reed told me later that he could hear Connor screaming through the phone when general counsel called him to ask what the hell this was. I would have paid good money to be in that room. The first response came from the daughter herself. She called my cell phone at 11 that night. She was crying, which surprised me because in the 10 years she'd run the company, I'd never seen her express any emotion stronger than mild irritation. She said, and I'm paraphrasing because I didn't write this part down, she said that there had to have been some misunderstanding, that her father had clearly never intended for the clause to be used in this way, and that we should sit down and work something out like family. I told her that I wasn't family, I was a vendor, and I'd been a vendor since the moment Connor had me walked out of the building. I told her she should talk to her attorney and have her attorney talk to my attorney. Then I said goodnight, and I hung up, and I went to bed and I slept the best I'd slept in about a year and a half. The second response came 48 hours later. It was a formal legal letter from the company's outside counsel claiming that the reversion clause was unenforceable, that the IP was clearly work for hire, and that they were prepared to litigate aggressively if I pursued the matter. Reed laughed when he read it. He said it was the kind of letter you send when you have no actual argument and you're hoping the other side will get scared and go away. He drafted a one-page response that basically said, "We have the original signed contract. We have the founder's written correspondence confirming intent. We have 26 years of internal documentation crediting me as the sole author, and we have a 60-day clock running. Your move." Now here's where the story gets interesting, and where Connor Whitfield's entire career started circling the drain. About 12 days after the first letter, while their lawyers were still figuring out how to respond to our response, somebody at the company decided to try to work around the problem instead of solving it. I don't know if it was Connor's idea or somebody else's, but the decision was made to bring in an outside consulting firm to rebuild the compliance database from scratch in a cloud-native architecture, with the goal of getting off my code before the 60-day window expired. The plan was to take the existing data, port it to a new system, and abandon my code base entirely. There were 3 problems with this plan. The first problem was that the data itself was not what they thought it was. A significant portion of the records in the compliance database were not just raw data points, but were generated through proprietary algorithms I'd written. Algorithms that calculated risk-weighted maintenance intervals, predictive component failure probabilities, and regulatory exposure scores. Those derived data fields were part of my licensed IP. You couldn't just copy them to a new system. You'd be copying licensed work. The second problem was much bigger. About 4 years earlier, when the company had picked up its first Defense Department contracts, the compliance database had been certified by the Defense Counterintelligence and Security Agency for handling certain classes of sensitive but unclassified information related to flight operations for government officials. The certification was attached to the specific architecture I'd built, the specific access controls, the specific audit trail mechanisms. You could not just spin up a new system and claim equivalence. Any new platform handling that same information would need to go through the certification process from scratch, which takes a minimum of 14 months and requires a cleared technical lead with specific credentials, of which I was the only one in the company who had them. The third problem was the one that finally ended Connor's career. The consulting firm they hired, in their eagerness to demonstrate progress to him during a status review, made a copy of the production database and moved it onto a development server hosted in a public cloud region that had not been approved for that classification of data. They did it on a Tuesday afternoon. By Wednesday morning, the automated monitoring tools I had built into the system, tools that Connor had specifically referred to in his first all-hands meeting as paranoid boomer over-engineering, had flagged the unauthorized data movement and sent alerts to the compliance officer on file with the agency. Because I'd been terminated, the compliance officer on file was still me. The alerts came to my personal email. I forwarded them with timestamps and full headers to Reed, who forwarded them to the appropriate federal contact within 2 hours. Federal investigators showed up at the company's headquarters on Friday morning. I learned about this from a man I'll call my old friend at the company because he's still working there, and I don't want to make his life difficult. He called me from his car in the parking lot on his lunch break. He told me there were 3 vehicles in the visitor lot that did not belong to anyone he recognized, that the daughter was in her office crying again, that Connor was in the main conference room with 2 people in suits and was visibly sweating through his Patagonia vest, and that someone had been spotted carrying out a server tower in a hard-shell case escorted by a man with a badge clipped to his belt. I felt a lot of things in that moment. I'd be lying if I said satisfaction wasn't one of them. But mostly, I felt tired. I'd spent 26 years building something to make sure things didn't go wrong, and the guy who'd been hired to replace me had managed to make things go wrong in approximately 10 weeks. The phone call I'd been waiting for came on Sunday evening. It was the chairman of the board, the founder's brother, a man named Walter, who I'll just call by his first name because I respected him then, and I respect him now. He apologized to me for 10 straight minutes before he asked me anything. He said he hadn't known what was happening until the federal investigators showed up. He said the daughter had been mismanaging the company since her father passed, and that the board was finally going to do something about it. He said Connor was being terminated effective Monday morning, and he asked me, very directly, if there was any way we could work together to fix this. I considered the question. I'd been considering it for a while, actually. Reed and I had been gaming out the endgame for weeks. There were a couple of ways this could go. I could enforce the full invoice, force the company into a settlement that would probably bankrupt them given their current cash position, and walk away with a lot of money and the satisfaction of being right. Or I could play it longer, smarter. I could come back as a consultant, on my terms, with the IP rights still in my pocket, and rebuild what they'd nearly destroyed. The second option made more money long-term, and it gave me something I wanted more than money, which was control over how the rest of this story ended. I told Walter I'd be willing to talk. I told him I'd come to a meeting on the following Wednesday, but only with Reed present, and only at Reed's office in Kansas City, not at the company's offices in Wichita. I told him there would be no discussion of the past, no apologies needed beyond what he'd already said, no rehashing of how we got here. The conversation would be entirely about what came next. The meeting lasted 4 hours. By the end of it, we had a framework agreement. The terms were these. I would return to the company not as an employee, but as the principal of my own consulting LLC, which I'd already set up the previous week with Reed's help. My consulting rate would be $1,400 per hour for technical work and $2,000 per hour for any work involving direct interface with federal regulators. A retainer of $120,000 was required upon signing, replenished monthly. The original invoice would be settled separately for a negotiated figure of $1,800,000, paid in 3 installments over 12 months. The IP rights would remain mine, and I would license them back to the company on an annual renewable basis, with the licensing fee structured as a percentage of revenue from contracts that depended on the certified compliance system. There was no non-compete clause. There was no non-disparagement clause. There was no NDA covering the circumstances of my prior departure. Reed was very specific about all of those points. I wanted to be able to tell this story. I'm telling it now. I would also have written into the contract the right of refusal on any technical hire above a certain seniority level. Not approval. Refusal. If I said no, the answer was no, and the company had to bring me a different candidate. Walter agreed to that one without even blinking. He said, and I'll never forget this, he said, if we'd had that clause in place a year ago, none of this would have happened. I started back on a Monday, 3 weeks after the agreement was signed. I drove into the parking lot at 7 in the morning, same as I'd done for 26 years, and I parked in the visitor spot closest to the entrance because I wasn't an employee anymore and I wanted to make that visible. The receptionist, a wonderful woman named Patty, who I'd known since her first day, started crying when she saw me walk in. She hugged me. She said, "We missed you so much." And I told her I'd missed her too, which was true. Connor was gone, of course. He'd been escorted out 3 weeks earlier. I heard later that he'd tried to spin the situation in a series of LinkedIn posts about challenging the status quo and the difficulty of driving innovation in resistant cultures, and that several recruiters in the aviation industry had quietly added his name to a list they share among themselves of people who should not be hired for safety-critical roles. Whether he ever lands somewhere else, I don't know, and I don't particularly care. He's not my problem anymore. He's never going to be my problem again. The daughter is still technically running the company, but the board has put what amounts to oversight in place around all of her major decisions. Walter's in the office 2 days a week now. He's 76 years old, and he should be on a fishing boat somewhere. But he told me he feels like he owes it to his brother to make sure the company survives. I respect that. I told him I'd help however I could. The federal investigation closed about 4 months after it opened. The company paid a substantial fine. The certification was restored only after I personally led the remediation effort, which took 6 months and resulted in a bill from my consulting LLC of just over $600,000. Combined with the original settlement and the ongoing licensing fees and the consulting work I've continued to do since, the total revenue from this whole situation has been somewhere north of $3.5 million over the past 14 months. I'm not telling you that to brag. I'm telling you because I want you to understand what 26 years of being underpaid actually looked like when it finally got rebalanced. But the money isn't really the point. I want to be honest about that. The money is nice. My wife and I paid off our house. We bought a small lake place in Missouri, and we set up education funds for our 3 grandkids. Those are good things. I'm grateful for them. The point is something else. The point is that for about 10 weeks last spring, I had to live with the experience of having a person who didn't understand what I did, didn't respect what I'd built, and didn't have the basic professional humility to ask questions before he made decisions, stand in front of people I cared about, and call my life's work garbage. I had to live with that. And then, because of choices I'd made decades earlier with the help of a man who believed in me enough to draft a contract that actually protected me, I got to live long enough to see that same person walked out of the building in disgrace while federal agents carried out a server tower behind him. Here's the part I want you to take away from this story. Whether you're someone who's been in your field for 30 years or someone who's just starting out, if you build something that matters, write down whose name is on it. Get it in ink, get it signed, get it notarized if you can. Don't trust handshakes. Don't trust the fact that everyone around you seems decent right now. People retire, people die, people get bought out, companies get sold, new people show up wearing vests and carrying notebooks they never write in, and they will look at the thing you built and they will not see the years that went into it. They will see something they don't understand, and the thing they don't understand will threaten them, and they will try to destroy it because destroying it is easier than learning it. If you've done the work, protect the work. Hire a lawyer once, early, and get the language right. Read what you sign. Keep copies. Keep backups. Keep a record of who did what and when. And if the day comes when someone walks you out of a building you helped build, with 8 minutes notice and a vest-wearing 33-year-old smiling at you across the table, you walk out quietly. You don't argue. You don't beg. You get in your car and you drive home and you call your attorney and you let the contract you signed 26 years ago do the talking for you. I'm not the bitter old guy who got pushed out. I'm the guy who designed the building they're standing in, and I still hold the keys. The revenge isn't in the money. The revenge is in being the only person in the room who saw all of this coming. I've thought about this story a lot in the months since it all settled down. Mostly at night, sitting on the porch of the lake place with the dog at my feet, listening to the bullfrogs and trying to figure out what I actually learned from it. The first thing I learned is that nothing happens by accident. Connor didn't get walked out of that building because the universe decided he deserved it. He got walked out because of a chain of choices he made, every single one of them small and avoidable. He chose not to ask questions in his first 6 weeks. He chose to laugh at me instead of listening. He chose to bring in a consulting firm that cut corners. He chose to ignore the monitoring tools I'd built because he didn't understand them. Every one of those choices was a seed, and the harvest came in exactly when you'd expect. That's not mystical. That's just how the world works. What you plant is what grows, and the people who pretend otherwise are the people who get surprised when the bill comes due. The second thing I learned is that intelligence without humility is just a faster way to fail. Connor wasn't stupid. He had degrees. He had credentials. He had the vocabulary. But he didn't have the one thing that actually matters in any field that's older than you are, which is the willingness to assume that the people who came before you might have known something you don't. I've made my share of mistakes in 58 years. The ones I'm proudest of getting through are the ones where I shut my mouth and listened to someone older than me, even when I thought I knew better. That habit has saved my career more times than I can count. The third thing I learned is that patience and preparation aren't the same as passivity. There's a version of the story where I walked into Connor's office on day 1 and started a fight, and I would have lost it. Because he had the org chart on his side. The version that actually happened required me to absorb a real insult, drive home quietly, and trust that the work I'd done years earlier, when nobody was watching, would carry me through. The contract I signed in 2011 wasn't an act of paranoia. It was an act of self-respect. I knew what my work was worth, even when nobody around me was forcing the question. And I made sure that someday, if it became necessary, the paperwork would speak for me. If I could leave you with one thing, it would be this. Build the kind of life where, when the worst day comes, the version of you from 10 years ago has already done the hard work to protect you. Be decent. Be sharp. Be the person who keeps showing up when it would be easier to walk away. That's the only revenge that lasts.